So once again, good morning, good afternoon, good evening to everyone, to our colleagues, partners, friends. Thank you for joining the webinar. It's a pity that we cannot hear you, but we can read the chart. So if you have any questions, please feel free to address ours, and we will try to answer the questions probably at the end of the presentation, perhaps maybe while we are speaking. So today we are two here. So my colleague Alina, trademark attorney and senior expert from the trademark department, and me, mainly mostly involved in the enforcement proceedings with the court, customs, and other enforcement bodies. And we will speak about re-entering Russian market, because now it's quite a hot topic for many companies, not only for ones which already came back, but also for businesses which consider whether to re-enter or not. And we received a number of questions in this regard, and therefore we decided to prepare this webinar and to shed some light on most hot issues, most hot questions in this regard. We divided our presentation into two key parts. The first part is about validity and enforceability of your own brand. Because as the first step, either you are re-enter or it is a first entry, you have to understand what kind of right you have and whether or not you may enforce them and what risk you face. And the second part will be about any other conflicting marks and obstacles you may face. And I will mostly speak about the first part, and Alina will deliver the information about second part. A few words about current situation and how it developed and happened. So as we all know, after situation with Ukraine in 2022, a number of companies, I would say 1,000 of companies left the market, and that was indeed not good for local market, for Russian market. And I know that most of the businesses which left the market, they also were in doubt, is it a good decision or not, or it's mainly about politics, and because the economy dictated a bit different decision. And after this, there was a wave of information from foreign mass media that IP cancelled in Russia, that the IP rights no longer protected in Russia, and so no chance to license, to enforce, and so on and so forth. But in fact, that was not true, and we prepared a number of articles and with the citations of the laws and official position of the Russian Patent Office, because all the authorities which involved in this IP field, they declare that no substantial changes that may somehow affect your rights has been taken, and you may continue doing business in terms of IP. And if you are interested in this field, you may again write us, and we will deliver this additional information to you. Because, as I said, there was many told about this. And now our companies are considering the re-entering, so they are coming back. I would say even in 2022, around 30% of the companies came back, and every year. So it's I just saw the statistics, and I found that around 400 companies now already returned. So anyway, for everyone who is considering re-entering or just launching from the scratch, everyone wants to know what is happening on the market this time, and therefore we decided to introduce this for you. So let's start, as I said, with the first part, with their validity and enforceability of your own brand, because when you come, you should be sure that you will have that you have rights and that you may enforce your rights. First of all, as before, you proceed, before you deliver goods and provide services, you have to understand that you have valid trademarks. So if you had one, please make sure that it is duly maintained. It was renewed, because so today we're talking about trademarks, and it's 10 years period for every time you have to renew your trademark after expiration of this term, and there is a grace period. In Russia, it is 6 years. 6 months, and so you still have chance to, if you are late, you may still renew your trademark. But this, I would say, the most transparent and easy matter to start with when you relaunch your business and re-entering the market. The second part, and more complicated, is the use of the mark. And we will now speak about this matter, and I will try to highlight the most interesting issues in this regard, because there were a lot of questions were raised in this matter. And so let's consider. So in some countries it is about 5 years, in some countries 3 years, in most of the countries it is about 3 years. So after 3 years, following the registration, any mark becomes vulnerable to cancellation due to non-use. Therefore, if you terminated your presence on the market in 2022, in 2025, you are in peril and under the risk of being cancelled due to non-use. If the business was restructured and the deliveries were rescheduled, the use is considered as proper one if the mark is used by the rights holder, by the licensee, whether it is registered license or not, it doesn't matter, and by a third party which is under control of the rights holder. All this three kind of use is considered as a proper and valid use. Therefore, if, let's say, before the military story with Ukraine, you had direct business relations with your Russian partners, but after you restructured and imported your goods through some other jurisdictions, but this still is under your control, that kind of use would be considered a sufficient one. So please take this note into account. And the control could be contractual or corporate. The contractual meaning that you have a number of agreements, and you should be in position to show this in court, that this is not just a delivery from some companies, but this is a chain of deliveries, and this starting from your jurisdiction, from, I don't know, from the official manufacturer, then it goes to some other countries, and then finally it goes to Russia. But if it is not your case, if it's not about this, then unfortunately the control will not be found by the court, and then maybe you have a corporate control, but normally it is about affiliated companies, and that also would be sufficient use, which is recognized by the court as a good one. The important thing is that this should be not only about advertising or import. The goods must be placed on the market, so it shall be a real presence on the market. The sales could be high or low, but still they must be, meaning that the consumer must have right to purchase that product. If it was not, then the court, the IP court, is not considering that kind of activities, that kind of presence as genuine use of the trademark. Another thing is particular products which were on the market. So we all know that, that there is a list of the goods and services normally in the trademark certificate, and when the mark is attacked, it is normally claimed a certain list of goods to be cancelled, and you are not in position to say that I haven't sold this particular goods, but I sold similar one. Except the talk is about well-known, some famous trademark, and the famous meaning you have to prove that the mark is really famous. Let's say we recently there was a case about Xiaomi, yeah. So, and the opposing party filed an application, Xiaomi Home, and tried to cancel Xiaomi trademark due to non-use for home appliance and there are other similar goods. And Xiaomi, they believe that they are very known on the market, and therefore they claim to enforce the trademark because of famous character of the mark, famous nature. But unfortunately, the court rejected Xiaomi because no evidence were submitted on fame of the trademark on the market. Quite a lot of questions were raised concerning the amount of goods, because some companies sell a few, other businesses trade a lot, and therefore it's not easy to make some conclusion about the amount of goods which shall be placed on the market. So the guidance here is that the amount depends on the nature of the product. If it is some luxury product, then the amount could be low, because normally it's not a kind of goods purchased daily on a regular basis. If it is about consumer products, then that must be some relevant amount of goods, I would say regular amount of goods. If that is the guidance for you to understand whether or not it will be perceived by the court as a proper evidence of use. Modified trademarks. Also, the story, a very popular story, then the mark is used not in the format is registered, but with some modifications and variations. So there are two key rules here. The first is that the changes shall not affect the nature of the mark, meaning that the general impression produced by the mark shall be more or less the same, and the distinguishing character shall not be changed. And another one is if you change some element, then that element shall not prevail in the mark. Here are a few examples. Let's say evolution and evolution, but this rule is about changing the language. So it was if it was in Latin and but used in Cyrillic, it's not good. It's not recognized as proper use, and normally that kind of uses that kind of marks are cancelled due to non-use. And the second example is about complex trademarks. Then it is word and design. So if some, as you see, dominating element was added or removed, then again it's not considered as a proper use. Boost and boost with the design, I would say this is quite disputable, because it depends on the court discretion, how the judge will consider this. To me, it depends on the overall view of the product, how it was used. Interesting thing, especially in terms of the current situation and the number of sanctions and contra sanctions which were imposed, are the some reason which are considered as legitimate, or which may justify the non-use. So the Paris Convention say that the right holder may say that the mark was not used due to some reasonable circumstances, like I don't know, a need to obtain a license from government. This is mainly about pharmacy and agrochemical products. It is restrictions and embargo from governmental authorities. The question is, however, whether or not these restrictions and sanctions shall be originated from the country of the origin of the rights holder, or from the country where the use taking place. So there is no direct answer in this regard in the convention, because it is silent about this, and we may interpret this rule, this provision, as no limitation in this matter, meaning that regardless the origin or the sanction, the right holder shall have right to say that this is my valid reason for non-use. We already have a few cases considered by the IP court, because, as I said, around 3 years already passed, and we have cases of non-use where companies try to make reference to current situation between Russia and some other countries. The answer is that just a mere reference to a general situation and general sanctions will not be applied, so would not work. The right holder must show some particular resolution, some particular rule prohibiting you from import this particular product into the Russian market. So if you are in the position to prove this, then it will be considered as a valid reason, as a justification of non-use. So the consequences would be that this term will be, I would say, calculated back, and you have to prove the use in the time which take place before the sanction was imposed, or before the before this particular reason, which you believe is excuse for non-use. Let's say here I decided to show one case for you to understand how the court handle a non-use case regarding the sanctions which were imposed by Argentina. So there was a trademark Koto, and it was registered for in general for meat, without any specification what kind of meat, any other specific part of meat. And the restriction was made only with regard to some particular cut of beef. And the owner cited these restrictions, but the court said, okay, you were not able to import this particular part of beef, but there are also any other different kind of meat and a different cut of meat. So please prove that you use your trademark for other kind of meat. And they unfortunately was not in position to submit this evidence, and therefore the mark was terminated, the protection was terminated. But again, it is important that the IP court considered the restrictions and found that this would sufficient only for some specific product. Another case is about Ericsson trademark, and the action was taken against air and heating devices. And the rights holder tried to explain that his product is in the list of so-called double application, and therefore they are prohibited from importing those goods into the Russian market. But then the question was raised in terms of, please prove that air and heating devices are in the list of double application. Unfortunately, the rights holder again was not in position to prove this, and therefore the court also terminated the protection of the trademark. So just sorry. Now let's consider the possibility of the trademark, because in my computer is slightly different. It's okay. Just so let's now consider what obstacles, what issues you shall take into account, and you try to enforce your trademarks. First of all, there was a number of cases at the very beginning. When infringers tried to protect by citing the fact that this particular rights holder, this claimant, is from unfriendly country, so-called unfriendly jurisdiction, which imposed sanctions, they left the market, and therefore the case must be dismissed, and the claims are not valid. It is abuse of right. But regardless these grounds, the courts keep taking the decision in favor of the rights holder, and just only a general reference to this status, let's say, to the status of the claimant, it is not enough to to defense against the claim concerning trademark infringement. So, and there was a number of cases where the rights holders, they effectively protect their trademark rights. So here I just specified a few examples, and the brands, and many of them initiated a number of cases, a dozen of cases, I would say, and the damages was paid, and the decision were made indeed in favor of the rights holders. And the Peppa Pig, I think the case which almost every jurisdiction is aware of it, because it was a notorious case, where the first instance court said that no infringement taking place, but then it was cancelled by the Court of Appeal and Court of Cassations. So it's working in a regular mode, and there is no, I would say, special rules or special new regulations which may affect your IP rights in this field. However, what you shall remember when you coming back, and when you decide to initiate some, let's say, court case or enforce your trademark, I think more or less we may face in almost every jurisdiction, because when you don't use your trademarks for a long time, for years, it's maybe 2 years or 3 years, or then indeed the consumers become less and less aware of your trademark, and therefore there is a risk, that the case can be dismissed just because no confusion taking place. The one of the elements of the infringement, of any infringement, is the misleading of the consumers, and therefore, if no confusion, just because the mark is never is not being used for a long time, that should be considered. That should be taken into account. I would not say that this is for sure, that this is 100%, but this is a risk. The same story is about amount of damages, because if you claim a high compensation, but you was not on the market for years, it's not clear why the damages shall be so high. And another matter is a parallel import. Let's say a few words about this. In general, in our jurisdiction, it is not allowed. Parallel import is prohibited. So we apply the regional principle of trademark exhaustion. It is 5 countries of the Union. You may see them on the slides. So if the goods are coming from one of those countries, and they were initially delivered to this country without consent of the rights holder, then it is not allowed to circulate them in terms of the Union. But if it was delivered with the consent of the trademark holder, then indeed the mark is considered as exhausted, and you are free. Sorry, not you, but the importer, any person is free to sell, to advertise, to distribute those goods. So this is about regional principle of trademark exhaustion. That was until 2022. However, once the situation changed, the government considered the amount of goods on the market, and the Ministry of Trade created the list of so-called goods allowed for parallel import. So this list is updated, I would say, every 3 months, depending on the shortage of the goods. And if the company is not on the market, so if there is no presence, If there is no goods of this rights holder on the market, and there is a low amount of those goods, then this particular product and this particular brand can be inserted in the list. In that case, you will not be able to enforce your trademark rights against parallel import. Only in case this particular product and your particular brand is in the list again. And this is a good example because the case initially was initiated with the customs, and it started very positively. First instance recognized the engine oil as counterfeit one, and therefore the decision was in favor of the rights holders. But on a later stage, in terms of the appeal, that was found that the goods were original. So it's not about, the dispute is not about counterfeits, but about original products. And therefore the case was dismissed just because you may see on the last sentence on this slide that parallel import allowed in case a company left the Russian market. And in that case, Hyundai and Kia, they were in the list, and therefore they was not lucky in this case. So what are the benefits of re-entering the market? Let's say, let's summarize what we just considered. First of all, if you're on the market, or if you are back, if you are re-entering, there will not be obstacles for you to fight parallel import. So the restriction will work, and those particular goods, if they were included in the list, they will be removed from the list, and we handle that kind of cases. We send the motions to the Ministry of Trade, they consider the motion and take a decision to remove the trademark from the list. This is indeed a good benefit for you if you are returning. So it's less risky in terms of enforcement, because then you're on the market. What we just considered the risks of being of compensation being reduced, or the case being dismissed just because of lack of confusion and misleading. Another thing is collecting royalties. Perhaps you know that now there is a special proceeding of collecting royalties for so-called unfriendly jurisdictions, because the royalties under license agreement must be first collected on a special account. Then there is a governmental commission which shall submit the permission for transferring those money from this special account to the account of the rights holder. So it's possible, but this is complicated. If you're on the market, if you are presenting, if you trade with the goods, the standard proceeding for collecting royalties shall apply. And almost the same, it will be much easier to get court awards, because now, before it was possible, then let's say we, like law firm representing foreign clients, we were authorized to collect money for our clients and then send this money to our foreign clients. Now the rule is that a foreign company must open an account in the Russian bank, not a special account, so but it shall be made by a foreign company. So it's no longer possible to collect for us money and to send them to a foreign rights holder. So this is also will be more easy for you to get court awards. And so finally, if you consider your, if you study your trademark rights, so you understand that unfortunately you have right, but you haven't used this for 3 years and you're under the risk, but you want to start business and you want to continue selling, manufacturing or providing services under this brand, we definitely recommend that you consider new filing or refiling. And now I'm happy to pass the baton to Alina. Yeah, so please take the stage and enjoy.
Thank you, Sergey. So my part of the presentation today will be about basically trademark examination procedures of foreign entities, and we'll start with the possibility of refiling the trademarks. We'll speak about attitude of the Russian Patent Office as regards new filings of the entities other than the genuine trademark owners. We will consider several cases, and we will talk about what can be done to combat unfair filings. So, about refiling. If you indeed facing the non-use cancellation action, or possibly you are fearing that you may face it in the near future, then refiling may be quite a good tool to keep your trademark rights safe. The obvious advantage of the refiling strategy is obtaining another 3-year grace period for non-use for the newly registered trademarks. The main point to be considered during the refiling procedure is that double registration is prohibited in Russia. Thus, filing the same mark for the same goods or services may face and obviously will face double registration objection. Naturally, it is possible to withdraw prior marks, but in this case, the applicant will lose the priority date of prior marks, which is of course undesirable. So an avenue to proceed could be filing for an amended trademark. This could be a slightly modified mark with additional word or graphical element, or another color combination may be used for the mark. Alternatively, if you wish to refile just for the same mark, then it is possible to amend the specification. The point with the list of goods and services is that the goods in the new filing may overlap with the previous one, but the items that you use should not be identical. Like, for example, you have registration for clothing in general, and then you may make a new filing for specific types of clothing. If you have a general registration for pharmaceutical preparations, then some specific types of medicines may be used in the new filings. And of course, both types of amendments, that is, changing the mark slightly and using another specification, will do the best. So, moving forward, what is the current trademark landscape in Russia? As Sergey has already said, recently there has been a lot of speculations about changes in the IP protection in Russia. And some media articles would even say that IP no longer exists in Russia, following some governmental decisions to allow parallel import in some cases in respect of certain goods and brands. But as a matter of fact, up to the present moment, the IP Institute continues working effectively to protect the rights of the IP owners from all over the world, making no distinctions between the trademark holders. All mechanisms for protection and brand enforcement remain operational and reflect the invariability of legal approach and procedures. Obviously, due to the fact that some of the foreign companies has left the Russian market, decided to wind down and sell the local business to the Russian partners, there has been a rise of bad faith filings. Some of the unfair market players has decided that time has come to make profit on the other brand's reputation and fame. So under such circumstances, what can be done to combat conflicting brands? Firstly, we should know that the Russian Patent Office carries out trademark examination both on absolute and relative grounds. Secondly, as previously said, the statutory mechanism remains the same, and all applications are treated equally with no politically motivated approach. In the evidence of such an approach of the Russian Patent Office, we would like to highlight 3 cases. The first case concerns Dr. Pepper. In this case, a Russian entity filed Dr. Pepper application covering soft drinks in class 32. The Russian Patent Office refused registration of this mark, stating that the applied designation represents the name of a soft drink created in the United States that appeared in Russia in 1996. The drink was produced by the company of the Coca-Cola Group. As such, the applied designation may mislead the consumers as regards the origin of the good, the manufacturer of the applied goods. The peculiarity of the case is that the owner of Dr. Pepper brand officially announced that it was terminated trading activities in Russia and even renounced all the trademarks for similar brands in Russia. Nevertheless, despite of their renounced trademarks, the Russian Patent Office pointed out to the fact that according to the information available on the internet, the brand was owned by the company that had nothing to do with the applicant of the new application. The brand was intensively used in Russia ever since the 90s, and as a result gained awareness and reputation among the Russian consumers. Despite the fact that there were no official sales for the last 2 years, the Russian consumers are very well familiar with the brand and the owner, and thus it makes it possible for their misleading to occur. So the applied designation did not mature into registration. Another case is for Roblox mark. As you might be aware, Roblox is an online game platform and game creation system developed by Roblox Corporation that allows users to program and create their own games and play the games of others. The company owns trademark rights for the respective goods and services. However, the Russian entity applied for stylized Roblox marks covering goods and services in class 30 and 35. This application was refused registration on the basis of misleading. When making the final decision, the Russian Patent Office considered extremely close similarity of the applied designation and Roblox trademarks, payment reputation of Roblox, and what is peculiar in this case, the examiner stated that the applied goods and services, though they are far beyond the business that conducts Roblox Corporation, might be perceived by the consumers as manufactured or provided by Roblox, since the provision of game services was often accompanied by the sale of various goods with the symbols of the games. So the consumers might consider that the goods of class 13 are produced by the Roblox Corporation or with their authorization, and such sales are used to increase the awareness of goods and services of the corporation or to increase the company's profits. So this application did not mature in the registration either. And the last case in this section is about Bluebird application, which is also filed by the Russian entity for class 33. The application was filed by the application was refused registration as it was considered it could be capable of misleading the consumers. The point in this case is that Bluebird Distilling, the owner of the Bluebird brand, doesn't have Russian registrations. Nevertheless, the examiners considered the case and indicated that the information available on the internet is sufficient for the consumers to learn about the Bluebird brand, and all the information on the internet about Bluebird and whiskey are connected with Bluebird Distilling. So the consumers can easily reach this information and may be misled about the producer of the goods. So this application was refused as well. The above cases show that the Russian Patent Office takes strict approach towards trademark examination procedure and protect the rights of genuine trademark owners. But what can be done on behalf of trademark owners to enhance the examination procedure? Here we come to the measures to protect the trademark. Actually, there are several options. The one is a passive one, and that is to wait the outcome of the examination procedure carried out by the Russian Patent Office. Otherwise, the trademark owners may choose proactive approach and monitor new filings. Once any undesirable filing is revealed, it is possible to file an observation letter, which is also called an informal opposition sometimes. The purpose of such an observation letter is to draw examiner's attention to the fact that the applied mark should not be registered as trademark for certain reasons. The grounded observation letter is taken into account by the examiners when making the final decision about the trademark. If by chance the undesired application matured into registration, the Russian legislation also foresees the possibility to invalidate the registered trademark. Generally, grounds for an observation letter, as well as for invalidation action, are the following. The first one is prior trademark rights or rights for other means of individualization registered or used for similar goods and services. Another one is misleading as to the commercial origin of goods. However, the observation letter provides the trademark holder with a unique opportunity to draw the examiner's attention to the grounds that are not actually verified during the examination procedure. For example, this could be similarity of the applied designation to the company name that is used in Russia, identity or similarity of the applied designation to a name of a famous person in Russia on the filing date of the application, or, for example, similarity or identity of the applied designation to the object of copyright. Of course, all arguments set forth in the observation letter should be grounded and supported by documentary evidence, otherwise they will be considered of declarative nature. Our practice shows that a well-rounded observation letter serves as an effective tool to prevent the mark from being registered. As to invalidation actions, as already mentioned, they may be, the ground for invalidation action may be prior rights, misleading, but also the trademark may be invalidated if the actions of the holder of the disputed trademark are recognized as unfair competition or abuse of rights, or if the trademark was registered in the name of the agent of the distributor of the client, of the genuine owner without the owner's consent. In respect of the latter ground for invalidation, we should note that it is not always that an agent or distributor acts in bad faith. Actually, their motivation may be quite positive. For example, the mark is supposed to be promoted in the market, but as Russia is a first-to-file country, a distributor may try to secure protection of the trademark. In any case, we usually and always recommend filing a trademark application in the name of genuine trademark holder, since business relations may change drastically and the mark will remain in the hands of the distributor, who may eventually pose obstacles to use of the mark by the genuine trademark owner. This slide shows an example of a successful invalidation action. So this type of action was taken in respect of registered trademark, which is Tidy Hall. The trademark was invalidated in particular on the basis of prior trademark rights for tied trademark. During consideration of the case, the examiners established close phonetic similarity of marks. The initial dominant element of the disputed trademark tidy shop was considered closely similar to trademarks tied from the point of view of its pronunciation. Element shop has been regarded as a weak one, as it is commonly used for goods in class 3. Also, dominant element tidy has been recognized similar in graphic representation to tied trademarks. And the examiner also established similarity of goods 3. What is more, the holder of Thai trademark supported the invalidation action with the evidence of acquired fame and reputation of their trademark among the Russian consumers, and this fact has been considered as well. As a result, the trademark was invalidated for laundry products in class 3. To sum up this part of presentation, we would say that the Russian legislation provides various tools for defending both registered and unregistered trademark rights from unfair marketplace. But likewise, in other fields of life, it is much easier to prevent the undesirable events than to solve the problem later on. In this sense, filing an observation letter is more cost and time efficient than initiating an invalidation action. And what is more, timely obtaining trademark registration is of utmost importance. So our general recommendations for present and future include timely trademark filing, monitoring and taking proactive measures to defend your brand, use your brand as registered in accordance with the use requirement, and in case you are facing non-use or you just want to secure your brand for future and current circumstances, then it might be possible to consider the refiling. So this is all from me for today. If you have any questions, please feel free to ask. We would also like to remind you that our colleagues will be attending an annual meeting, and we'll be glad to invite you to our hospitality suite in San Diego.
Thank you, Alina. So I see that we don't have any questions yet. So maybe please feel free to answer if you have ones. So I have a question to Alina. So if I face some conflict in mark or application, am I limited in time, or I may take action anytime when I don't know, feel that now it's more affect me, more dangerous to my business?
If we talk about invalidation actions, basically most of them applies to the whole term of validity, with the exception of prior rights. In this case, the mark may be invalidated within 5 years from the date of trademark publication. In terms of observation letter, we have somewhat limited time scale and not at the same time. The fact is that there is no deadline for filing the observation letter, but it only has to be filed till the official action of registration is issued in respect of the application. And this is quite unexpected period, because usually the examination procedure takes 5 or 8 months, but also there is a possibility to accelerate the examination procedure, so you never know when it is the right time. And thus we usually recommend to file the observation letter as soon as possible, as soon as you are aware of the conflicting brand filing.
Okay, thank you. So if it's about infringement, yeah, and so if it's pending, then you are free to take action anytime you feel that now you are ready and you want to take. But if it happened once and after this that was terminated, so you normally have 3 years for taking actions, so limitation for actions in this term. So I see the question. So do the bank account of the Russian Patent Office fall under the sanctions? I cannot answer for sure right now. So as I know, we pay our fees for our clients, and because this is the kind of cooperation between us and our foreign clients, and we indeed don't have any question. I don't have any issues, yeah, in this regards. Perhaps you may know something more about this, whether or not it is included. I heard that some the account of Bank of the Russian Federation was included in the list of the accounts under the sanctions, but the Russian Patent Office, no, I didn't heard about this. And also what I heard, let's say if you want to pay some official fee, then you consider the case in court. This is not about Central Bank of Russia. This is some governmental account which is used for this particular purpose, but this is not central bank. We may clarify this issue if you have some special case for you. And yes, we will be in San Diego. Our trademark people, our lawyers, our patent people, patent specialists. So please feel free to come, even if the schedule is quite tight. But I guess we will find a proper time for you to discuss this in general or some particular matter you have, and we'll be happy. Yeah. Okay. Again, thank you very much. We hope that this was helpful. Yeah, because we think from what angle we shall deliver this information for you, and we decided that this amount of information is the first one you have to be aware of. But if you feel that any additional information is needed, please feel free to contact us. So have a good time, good day. Staying in touch. Bye-bye. Thank you.
Thank you.